question is, will I have to be in court with my attorney? Every single personal injury case is unique. The question is whether or not you will have to be in court with your attorney depends on the facts and circumstances of your case. Every case will have to be decided on its own merits, and whether or not you need to be in the courtroom for the entire proceedings or just for your testimony will depend on the circumstances of your case. We've handled this issues many different ways depending on the facts of the case. In one particular case, we had our injured client show up for his deposition, for the courtroom appearance for his trial testimony only. In that instance, our client was in a wheelchair and attending the trial for the entire length of the trial would have been somewhat burdensome for him. Depending on people's schedules also, it is certainly permissible for the injured party to be present by video camera or through their presence just for their testimony. However, in most cases, most people, if the case were to go to trial, which is by far the very, very low percentage of cases that actually do go to trial. In most cases, in the instance where the case would go to trial, it usually is beneficial for the injured party to be in attendance at the trial. The jury is able to see how that person interacts at the counsel table with the attorney and with the paralegal. Every trial is decided based upon the facts of the case, and a lot of times the jurors want to see the injured person at the trial. They're deciding that person's future. Their fate is in their hands. If the jury has to be at the trial every day attending it, usually it's a good idea for the injured person to be at counsel table during that trial to hear the testimony, to understand what's going on during the case. There's several reasons why the client usually should be at the trial. Many times during trial, during jury selection, during opening statements, insurance companies will attempt to begin negotiations during trial to want to resolve the case after they realize that their defenses, their denials, their avoiding responsibilities have come to an end, and they wish to try and make settlement offers on a case. It would affect the ability to go ahead and relay that information to the injured party to see if the case can be resolved. We have many instances where cases have been resolved right at the start of trial. Insurance companies unfortunately have what's called a triple D defense: delay, deny, defend, and many times until that trial starts, they have not offered any money. We've seen offers of zero, no money, or maybe a nuisance value offer of $1,000 or $2,000 turn into significant monetary offers beginning at the start of trial. We've had several cases resolved where there were no offers to right at the start of trial. Obviously, any settlement must include the client's authority to settle, and the client was not at the trial. It'd be difficult to get their approval for settlement. So in the instance, most clients will be attending trials, or at least portions thereof, at the trial. If you have any questions, please call the number on this website, and we will be happy to answer all of your questions.